So in closing, when I say the subversion of American democracy in my subtitle, which may be a bit too aggressive, I'm speaking of American-style democracy, the founders' vision born of their rebellion against a king, of using checks and balances to prevent the concentration of government power. I'm not talking about democracy per se. After all, presidents, whether they're subject to the rule of law or not, still must face election every 4 years. But I believe it is a fundamental principle of democracy writ large that if a nation's governing system is going to change, it should only happen after an informed public debate and a demonstrated mandate from voters. Back in 2000, as I mentioned, the Bush-Cheney campaign said nothing about their attitude towards presidential power to voters, even though expanding presidential power would be a conscious and central agenda from their first day in office. Last December, I grew frustrated with the fact that the 2008 presidential candidates were again volunteering little about their views of executive power and what limits, if any, they would respect on their own authority if one of them were entrusted with the White House, and nor were debate moderators asking the questions. So I drew up a survey of a dozen such questions and submitted them to the 6 leading candidates in each party ahead of the Iowa caucuses. And I got back detailed answers from 9 of them, including Senators Obama, Biden, and McCain. His are less interesting now than they were a couple weeks ago. There were some interesting patterns. McCain, Obama, Biden all distanced themselves from the Bush-Cheney legal theories, as opposed to, say, Mitt Romney, who enthusiastically embraced or implicitly endorsed everything Bush has claimed and done. McCain, Obama, and Biden all said the president, for example, had to obey a law governing surveillance or torture unless he can get Congress to change it, even if he doesn't want to. Still, there were some differences. Interestingly, McCain said that he would never issue a signing statement if he were president. And Obama, while criticizing Bush's use of signing statements as too aggressive, said that he would keep using the device when he decided that legislation he was signing contradicted the Constitution. So, after McCain and Obama won their respective nominations, after the Iowa caucuses and the primary process, interestingly, and as the power of the presidency grew tantalizingly closer to both of them seemed to back away from a little of that reticence. Obama, after saying he would never support a law locking down in statute the president's warrantless wiretapping program if it gave legal immunity to the telecommunications firms that allowed the administration to violate the law, turned around and then voted for exactly that legislation anyway. Less importantly now, but more dramatically, a top advisor to McCain, once he had won the nomination, said that McCain now believed that the warrantless wiretapping program had been legal all along because of the president's commander-in-chief powers, a view that totally embraced the Bush-Cheney's theories. So now President Obama is going to be president, and the question is, what is he going to do? His answers before the Iowa caucuses were quite limited. He was already backing away from that as the primary process grew on. And now he's surrounding himself by Clinton administration lawyers. So we'll see what he's going to do. We have to remember that even the Clinton administration was no slouch when it came to executive power. They used signing statements extensively, though nowhere near the scale that the Bush administration has done. But even more interestingly, in 1999, in the Kosovo conflict, Bill Clinton launched that combat without congressional authorization and allowed it to go on for 78 days, becoming the first president and only president so far in U.S. history to violate the War Powers Resolution that was imposed on Richard Nixon during Vietnam. So these same legal team are now flooding back into the White House, and we will see what happens. But even if future presidents renege on their promises, I believe that it is important to ask them the questions, and that there is value to having their pre-Iowa answers on the record, so that we can at least hold them accountable and draw public attention to those occasions when they fail to live up to what they have said. And I think that in the future, aspiring presidents should be required to tell voters in detail what they think now, not after one of them has already moved into the Oval Office. So once again, I'd like to thank Washburn and particularly General Romig for fostering public discussion of this critical issue. It's an honor for me to be here as part of this conference. Thanks for each of you for listening and taking an interest, and I'd be happy to move to questions if anyone has one. Thank you.